All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Morning, please be seated. Welcome to the 4th Court. This morning, the court will now call 0421-295 CR in the matter of Brian Dale Nixon versus the state of Texas. May I invite announcements, please? First from Appellant's Counsel.
Your Honor, Michael Gross for Brian Dale Nixon.
Morning, Counsel. You've been apprised of the minutes that you've been allotted, so I invite counsel for the appellant to approach and you may begin.
Good morning. My name is Michael Gross. I represent the appellant in this case, Brian Dale Nixon, on his direct appeal from the 454th District Court, Medina County, Texas. With the court's permission, I'll orally argue points of error 1, 2, and 3 and rely upon the brief for the remaining point of error dealing with the fair cross-section representation of the community. So the question for the court this morning is a jailhouse setting inherently prejudicial and thereby offends due process? In other words, is a trial in a county jail analogous to a defendant being forced to wear jail clothes during trial? I've looked at as much case law as I can in Texas on the issue, so is my opposing counsel. Opposing counsel brings up the Sterling case in their briefing and frankly relies solely on Sterling for the proposition that, look, this is similar to an issue at trial where we have to show harm as a result of what happened. It's our position, though, that it's not, and the Sterling case, by the way, talks about too many guards in the courtroom hovering around the citizen accused during the trial. Our position is that with the Estelle case and the Holbrook case that we've cited in our pleadings, that being forced to have a trial in a jail, and you all saw the picture of the jail in the briefing. And frankly, it's the first time in 35 years I've put pictures in my statement of facts. Our position is that being forced to have a trial on a capital murder case in that kind of setting is completely different from being forced to have different guards around you in the courtroom, because guards in the courtroom, according to the Holbrook case and the Estelle case, guards in the courtroom, jurors won't know exactly what they're there for. Maybe to keep the gallery from getting out of line, outbursts in the courtroom, in the gallery, different things like that in the well, but not necessarily the citizen accused who's standing trial. As opposed to that is the more appropriately analogous situation where an accused is forced to wear jail clothes during trial. I mean, that shows that that individual is in custody, is dangerous, couldn't make a bond, and it gives the opportunity for jurors to have adverse inferences as a result of the jail clothes. Same thing if you have to be tried in a case where you walk into the Medina County Jail, and that's all it says in that imposing facade there at the jail. They have to walk, the potential jurors have to walk through that. And you saw the pictures in the statement of facts where they then are confronted with the security immediately. And then right beyond security, they see attorney-client meeting rooms that are locked, heavy metal doors. They see the secured area where they have to go, where folks have to go to meet with clients, and where clients and were accused or kept confined in the jail, and convicted people confined in the jail. And then to your immediate left as you walk in is the courtroom. Now the prosecutors tried to say during the hearing at trial, and they've argued on appeal here that, look, the alternative, which was the courthouse downtown, was not sufficient. And it's kind of a stretch on the facts that you saw at the hearing, where they said, the trial judge heard some testimony from the chief deputy there at the Medina County Sheriff's Office that It's a multi-floor facility, the courthouse downtown. Yet, we're concerned that jurors might see the accused while he's handcuffed, or restroom facilities, or the jury deliberation room. Well,
Counsel, did all of that evidence come in from?
I'm sorry.
Only that evidence regarding the insufficiency of the Medina courthouse. Was that evidence proffered before the trial judge solely from chief deputies?
It was
Testimony,
evidentiary.
or was there any additional testimony that offered evidence to
No.
support, any finding that the courthouse, the Medina courthouse, was insufficient?
No additional testimony that I saw, Justice Martinez. But more importantly, it doesn't matter. It's just like, as an analogy, Justice Martinez, let's say that I have 10 people that want to sit in during jury selection to support my client during jury selection. And the judge says there's not enough room. Well, the case law is clear. You need a bigger courtroom then, because you're allowed to have those people in. Our point of error is not that the trial should have been held in the courthouse downtown. Our point of error, and what was argued at the trial level, it should not have been held in the jail at the Medina County Jail.
Sorry to take you down a bunny trail by interjecting that question while you were sharing, but let me backtrack and ask you more generally. You do raise 2 points of error. One specifically that there was unfair, let me get it right here. That the appellant had a constitutional right to an impartial jury, and that also his right of due process was deprived him of a fair trial. Are those two distinct or intertwined arguments that are analyzed, should be analyzed on review together or separate? Is there anything that separates or distinguishes our review over either point of error?
So, Justice Martinez, with point of error 1, we said being tried in the jail is a violation of presumption of innocence. And point of error 2, that the being tried in the jail was a violation of the right to due process. And you're exactly right, Justice Martinez, same facts, same analogy. However, the presumption of innocence, which of course is not in the Constitution, but has been held by case law that we cited in our briefing to be of constitutional magnitude, presumption of innocence, where we laid out the factors that having a trial in a jail room, in the jail itself, in a courtroom, that erodes the due process, just like it erodes the presumption of innocence.
Essentially, that it was inherently prejudicial.
Exactly.
Very good. So to your second point then about your deprivation of due process claim, how is that distinct from that first point of error? If it is.
Sure. So the two are intertwined with respect to due process. Violating the right, the presumption of innocence results in a due process violation. I still split it out. Well, first of all, I'm always worried about multifarious points of error, and I didn't want to have a multifarious point of error. So I split those out. But you're right, Justice Martinez, in the arguing, for instance, in the Jaime case that we cited out of Washington, they talked about how it erodes the presumption of innocence, resulting in a violation of due process. Now, we're not claiming that the right to public trial was infringed upon, where public couldn't get in there. We're just saying that being forced to have a trial in a setting like that results in a violation of the right to due process and results in the eroding of the presumption of innocence.
And would that require then, or do you assert that need we review then that second prong under, a determination of whether or not it was inherently prejudicial? Or if it wasn't, then the appellant would be burdened to show actual harm. Does that analysis apply the same way?
Right.
Very good.
So the state wants you all to take the position that was held in Sterling, for instance, where we have to show harm resulting from it. Our position is it's constitutional error. Violation right of due process, constitutional error. The violation of the presumption of innocence is constitutional error. Now you all are to the position where you have to determine beyond a reasonable doubt that it did not contribute to any harm in the case. That positive point of error, rather than the one the state is asking you all to take under the Sterling case, which is in opposite to the facts we have here, the state wants you all to just say, we have to show harm. We have to show that the jurors thought adversely in effect about what happened. And that's not what the case law says. If this court were to find that these facts are analogous to being tried in jail clothes.
Counsel,
If that's the case,
Counsel,
then under Holbrook and Estelle.
One second,
sorry,
counsel.
can I interrupt you?
Oh,
just
absolutely,
for a
Judge.
second? Sorry. I wanted to ask you, just getting into the facts a little bit, did the jurors ever learn the reason that the trial was being held at the jail? Was that ever mentioned in the record?
No, Your Honor. No,
No,
it's
not
not.
at all.
Stop.
Okay. Okay, thank you.
And the panel was not voir dired on whether it affected their ability to be fair and impartial jurors because of the setting.
They were not. And the reason being, I believe, a fair reading of the record of trial is that the Holbrook case that we cited in our brief, the Supreme Court case of Holbrook, was being relied upon by the defense team in this case, because, Holbrook made it very clear that the juror's state of mind is not dispositive here, because there's the high probability of prejudice being tried in that arena. And the Holbrook case takes us through a wonderful little reasoning for why it's not important what the jurors think. Little stock need be placed in the jurors' claims to the contrary, because they have no idea. They haven't been in that situation before. They have no idea what to expect walking into the jail. People have no idea what kind of horrible experiences jurors have had with the jail, or potential jurors. Have they had loved ones in that jail before? Are there actors being confined in that jail who had committed violence against extended family or immediate family of the potential jurors? Things like that. And Holbrook is very clear that, look, there's inherent prejudice, as you have said, Justice Martinez, which is our argument. The inherent prejudice means that it doesn't matter what the jurors thought about the trial being held in the jail itself.
So the brief does go into mostly about the presumption that it posed an unacceptable risk of that the presumption of innocence would be eroded, right? So it, in an act inherently prejudicial, like that, for the court to determine that it's inherently prejudicial, again, taking Estelle and Holbrook and the guidance provided by the CCA.
But can't quite hear you. Right?
Sorry. You rely heavily on Estelle and Holbrook by the CCA, and in their analysis about actual prejudice, to determine that a setting is inherently prejudicial, it does outline a two-prong review, does it not? One, that our court would have to find that the setting at the jailhouse correctional facility created an unacceptable risk that the presumption of innocence will be eroded. One. There's also a second prong that it does not further an essential state policy. This is not quite flushed out a bit, but what is your position on that second prong?
Great question. So the case we're relying upon there is, so in Estelle and Holbrook, the court said, trying, and the analogy was, the facts of those cases, which I'm saying is an analogy to this case, forcing, you remember the Estelle case was in Harris County, back in the day, Harris County, if you didn't make bond, you got tried in jail clothes. And so the Estelle case, the US Supreme Court said, that doesn't further a state interest. Like, for instance, shackling. Shackling or gagging may forward a state interest because a trial judge wants an orderly trial. But to the contrary, forcing an accused to wear jail clothes during trial, it does not further a state interest. Just like in this case, forcing an accused on a capital murder case to be tried in a jail, it does not further a state interest. Now, the findings of fact that were made by the trial judge dealing with space in the downtown courthouse, the restroom facility, it was never fleshed out how many restrooms were in that. I refuse to believe there's only one restroom and one conference room in that courthouse downtown. But again, that's a rabbit trail, because our position is it shouldn't have been tried in the jail.
Counsel,
And
can I interrupt you? again?
Absolutely, Your Honor.
Was there anything in the record about any other trials being held at the jail, or any reason why it was held at the jail in any other cases? Were they referenced to in any other trials that were held there?
No, Justice Rodriguez, the closest they came was saying that trials have been held here before. Well, that doesn't make it right, but that's the closest they came that I saw on the record. Justice Rodriguez was, hey, we've held trials here before.
Were the jurors aware of that? Or is there anything in the record that indicates?
Zero in the record about that, Justice Rodriguez. Nothing at all in the record about that.
Okay, thank you.
And so, Justice Martinez, it's our position that it doesn't further a state interest to hold this in the jail.
Well,
Because
let's ask more specifically, what do you understand to have been the state's position downstairs, at the trial level, presented before the trial judge? What convinced the trial judge that in fact it did further a state interest to do that? How would you respond to that contention as you understand it?
Oh, I think it's clear it did not further state interest because they had jury selection over at the stock show and rodeo area.
Right. What do you understand to be the state's position on it at the trial level that you understand might have swayed what would certainly persuaded the trial judge, and what would be your response now? I was going to ask you on rebuttal, but why don't we ask you now?
Sure. To be fair to the trial judge, he was a visiting judge. He hadn't tried a case there before. In fact, the trial judge asked Deanne, the coordinator in the record, didn't we try a criminal case down at town at the courthouse at one point, not too long ago? And Deanne, the court coordinator, there's not a response on the record, but the trial judge, he distinctly said, and a visiting trial judge, to be fair, said, I think we tried a criminal case down at the courthouse downtown. Now,
Let me repeat my question. What do you understand to be the state's position that was proffered before the trial court? Let me ask you that part. What do you understand to be the state's position about what state interest was furthered? What essential state policy was furthered?
well, they said security, and their witness, Chief Rodriguez, I think it was, he said he had security concerns, but not about Dale Nixon and not about escape or security, anything like that. His concern, and this was the only thing, which is why I don't think it was a security concern. The chief said, I'm worried about the jurors seeing the defendant in cuffs while they're at the courthouse. Well, that's the occasion in any courthouse you're ever in. That's not a security concern. It's even a concern here in this courthouse. I've picked death penalty trials down in the central jury room, and we're concerned about the potential jurors seeing the client come out in cuffs or shackles.
The concern about the defendant being seen by the jury with handcuffs was a concern raised by the appellant or by the state?
It was raised by the state's witness at the hearing on this motion. And we don't see how that's a security concern.
Was there any other essential state interest articulated by the state when challenging your request to change venue and move it to the courthouse?
On our request to be tried at a place other than the jail, the only things that the state brought up through their testimony at the hearing was that odd security thought seeing Mr. Nixon in cuffs by the jury, and one conference room being available. And that was the extent of it, Justice Rios. And it's our position that that's not a security concern, that there's nothing that that serves the state interest on having Mr. Nixon tried in a place other than the jail, especially since, just to come back a little bit, our point of error is we shouldn't have been tried in the jail. Not that we should have been tried downtown at the courthouse, because jury selection was out at the stock show. Why not have the trial out there? I mean, there's other places that could have been selected. And so we disagree with the red herring being forced to say that the only venue available was the courthouse downtown, even though I think that would have been fine, which, by the way, dovetails into point of error 3, which is the statute that deals with you can't try a guy for a trial in the jail. The state tries claiming a different statute, but we say the two act in tandem. There's nothing inherently conflicting between the two, because it allows you to be tried anywhere as long as it's not a jury trial in the jail. So with that, I see my time is up.
I'll invite you back on rebuttal. Thank you.
Thank you.
Morning, Your Honors. Ed Shaughnessy for the state on this matter. I, along with 2 members of the Medina County District Attorney's Office, tried this case. And I guess there's some clarification that should come into play. Originally, this case was being pursued as a potential death penalty case because it was a multiple murder or a serial murder, one way or another. In any event, that's why the jury selection envisioned bringing in a large number of potential jurors. And that would have precluded using the Medina County Courthouse because of the COVID distancing requirements. So with the assistance of the district clerk and other Medina County officials, the jury selection process was conducted at the Medina County Fairgrounds because of the distancing requirements. And that necessitated, I know this is kind of bizarre, but it necessitated the county renting a portable restroom for the defendant to use in the event he had to use it, because if they didn't have it, he could potentially be using the same restroom as members of the potential jury.
Counsel, we're here before, but what's before us right now is as it relates to the proceeding being held at the correctional facility. It's less about the fairground and.
Well, I understand that, but Your Honor, this is Mr. Gross continues, and his lawyers at trial continually referred to this as a jail courtroom. It's not a jail courtroom. It's a courtroom in the same building as the jail and the sheriff's office.
Was I don't believe it's uncontested that the record reflects what basically the environment at the correctional facility. It's uncontested that this was held at the Medina County Jail.
And I'm not contesting what and have never contested what the photographs demonstrate. That courtroom has been in that location and that environment for 30 some odd years.
So let's pick up where the court left off in questioning appellant's counsel with regard to the essential state policy.
Before we go there, may I ask something, since it's a follow-up to what he just
Please
said. So you, Mr. Shaughnessy, say that it is a courtroom in a jail, not a jailhouse courtroom. Explain to us what that distinction is
Okay.
for you.
It's one building that houses 3 separate entities.
Right.
It houses the sheriff's department, it houses the jail, and it has a courtroom. And I have seen similar setups all over South Texas. where if a new jail or a new facility is built to replace some courthouse from the 1880s, they put the courtrooms adjacent to the jail to prevent various assorted issues from arising, primarily regarding transporting inmates from the jail to the old courthouse. And they're scattered all over the area. The Medina County facility has been functioning that way for as long as I've been going down there, over 15 years.
In your mind, what is a jail courtroom?
Well, there's a jail courtroom in the Bexar County Jail where the public is not allowed in for purposes of a proceeding, where you have to pass through security, and the only people who are allowed in the jail courtroom are the lawyers and the defendants who are brought out of the jail and appear before the judge in the jail court. That's not what you have here. That would be a jail courtroom.
But can I interrupt you? That so
Sure.
the first thing that jurors are seeing, and we have copies of the trial exhibits, and so one of the exhibits was literally the entrance
Sure.
right, to the facility.
Right.
So are the jurors walking through the front entrance that says?
As far as I know, that's the only way they could get in.
Okay, that was my
Yeah.
question. And so, is this the normal place where trials are held in every case? Is it in this facility?
Well, as far as I know, that's where they're held for all the reasons that were stated previously.
So the courtroom proper at the courthouse is not utilized for trials?
For criminal trials?
I think it might be used for people who are on bond on felonies and for misdemeanors.
Okay.
But as far as I know, that courthouse is not where trials are normally conducted.
Okay, so I just want to, and I may be skipping ahead, but I don't want to run out of time. I want to,
I don't think you can run out of time.
I want to focus on the trial court's findings when he made his decision to deny the appellant's request to have the trial elsewhere. And he stated 4 things: security issues, concerns about the defendant commingling with the jurors and the limited space, the lack of bathroom facilities, and technology at the courthouse. Those are the 4 things that he articulated. Can you direct us to the supporting evidence in the record that supports those 4 findings by the trial?
Well, I think with respect to the technology aspect of it is, I think that was the state and the defense at the time. It would be more convenient to utilize the courtroom in the jail facility because of how it was wired.
But did they have a witness testify to that, or was
I
there-
think that was more of a representation by the Mr. Simpson, one of the prosecutors.
But we know that case law says convenience is not sufficient to
No, I
satisfy.
mean, that's not, we're not going to say, well, it was more convenient because we could get our PowerPoint racked up easier. That's not what we're relying on. And the intermingling aspect, what that involves is the jail in Medina County, where Mr. Nixon was housed, is roughly 1.5 miles away from the courthouse downtown. And that would require him to be transported every morning back and forth to the jail. And that exposed the possibility of some member of the jury seeing him being transported and having to be walked into the jail in shackles. That was the possibility that the judge was trying to prevent, because the way the trial was conducted, Mr. Nixon just appeared in the courtroom wearing a suit. And, there was never a possibility that the jury would see him in any other environment other than standing in the courtroom or sitting in the courtroom wearing a suit.
How did they handle that during the voir dire, though, at the fairgrounds?
Which part?
I mean,
Well, it was difficult because they had to have a separate bus and him come in through a separate entrance.
but they were able to do that.
They pulled it off, yeah.
Can I, excuse me, could I ask, in addition to what appellant's counsel shared about what was presented before the trial court about to support the essential state policy that was furthered, you point out again about viewing the appellant in cuffs. He also notes that there was some mention about a conference room, only one conference room being unavailable. Was there anything else in the record that would support a finding that an essential state policy was further?
Well, I think the conference room aspect was more related to the convenience for the defense to consult with their client.
Was there anything else then with regard to an essential state policy that was furthered?
Well, the aspect of avoiding having the jurors exposed to Mr. Nixon in a custodial fashion. That was the problem that the judge was trying to avoid.
Now, what I was able to find in the record, when Deputy Rodriguez testified, he was asked, what are the security concerns we would have? And his answer was, and we've discussed them, this was his testimony, the lack of space, number one. Number two is the conference room that was discussed earlier also serves as the jury room. So it would be very difficult to separate the jury from the defendant, and or restroom facilities. That was the testimony.
Right.
Is there any other testimony?
No, I mean, the testimony regarding where to conduct the trial was not extensive. You found what the state relied upon in terms of testimony.
And as far as the judge, when he made his decision, he says, in addition to the security issues and addition to mingling with the jurors, the lack of bathroom facilities. I think we put on the record previously the lack of technology. This is all I could find in the record where the judge makes his
Right.
ruling, his decision, his findings. Are there any other findings in the record?
Not to my knowledge, no.
So there
But what
were,
else? But I think it's more important to focus on what else is not in the record. And that is any evidence that any member of the jury took into consideration in determining guilt or innocence, whether or not the building said jail on the front.
so that would go to actual prejudice? Is that?
Yes, indeed, Your Honor. And this is, from my perspective, this is this functional equivalent of a motion for new trial asserting that the jurors considered evidence outside the record. That would have had to have been filed in this case. Bring the jurors in and ask them, did you consider the fact that this case was tried in a building that said jail on the front in determining the guilt or innocence of the defendant? That did not happen. The jury was instructed about the presumption of innocence, and there is no evidence that they disregarded that or considered anything in determining his guilt or innocence other than the evidence that was presented. And then that should be the test as to whether or not he's entitled to a new trial.
So is it your position then that the jury instruction given to, at the end of the trial would have
I
cured
think-
any potential prejudice by
I
the?
think jury instructions in that regard are presumed to have been followed by the jury. Appellate courts presume that the jury obeys jury instructions all the time. And there's no indication that they violated it in this case.
I'd like to go back since you underscored the point the state makes on appeal that this particular courtroom, as you invited the court to consider, was within a facility that albeit was part of the Medina County Jail.
They
And
shared the same building, yes,
if I may,
and they still do.
if I may.
Mhm.
We see guidance from other cases where the court on review does not determine that that setting was inherently prejudicial, in large part because they consider whether or not the facilities and activities of the prison, the jail, was remote from the courtroom, meaning so when a jury or juror comes in, any member of the public comes in, they're almost unaware. They are without any view of any activity by the correctional facility, any physical or activities of the prison, whether it's going through security, getting wanded, seeing, what we see in these exhibits. Does the state contend that, like those cases where a courtroom is again separate from view, remote, as the courts have used, is that the case here in the Medina County
Well,
Jail?
The photographs speak for themselves. If you stand in the lobby of that facility, you can't see any activity related to the custody of the defendant or
Right.
defendants. All you can see are a receptionist from the sheriff's department and some doors to visitation rooms. That's all you see. You don't see inmates, floating around in the background wearing jail clothing. And this, to me, Your Honor, is the functional equivalent of arguing that you can't try people in the Cadena-Reeves Justice Center because outside the Cadena-Reeves Justice Center, there is a bus from the Bexar County Jail bringing people into the facility in handcuffs. How's it any different? It's just a difference in degree.
Is there any supporting authority to support that?
No, it's
contention?
just the fact that would just be a variation on the facts arising from, well, if the jury knows something about where the trial's being held and why it's being held there, it could be prejudicial. And if you're going to argue that I was inherently prejudiced, you should bring forth proof other than to just say, look, here's a picture of the facility I was tried in. It must require a new trial.
So counsel, can I ask you, what other ways could the jurors have interpreted this? I mean, some of the case law talks about how the jurors could have interpreted other reasons for trials being held in certain places. But here, what other inferences could they have made walking into a facility that has the word jail in front of
Well,
it?
Your Honor, Medina County is a small county. There's no telling how many of the people who ultimately served on that jury were aware of what was in that building and how long it had been that way and what went on in there. And I think it's a stretch to say, well, if we try it in a place and it's got jail over the front door, the defendant must be guilty.
Well, were other alternatives considered?
Well, I suppose you could move it to a different county, but there was no evidence presented that the county that might be available had a different type of facility or would present lesser security concerns.
But was that considered in this case? Like in the record, is there?
No, I don't believe so. It was never considered as to whether, well, let's transfer it to George West County or Frio County or something along those lines. The only request was, we don't want it tried in this particular place, in this building.
Can you just restate the security concern? What is in the record that specifically speaks to the security
Only
concern?
the testimony of Deputy Rodriguez regarding the transportation of the defendant from the jail to the downtown courthouse. That's what he was referring to.
And that's a security concern?
Sure, it's a security concern because, one, theoretically, you're transporting someone from point A to point B, and that theoretically could increase the chances of escape. And two, it's a security concern in that it exposes him potentially to jurors who should not see him being transported in that fashion. Because if you even see him getting off the bus, you're going to reach the conclusion, oh, must be in custody.
But there was nothing in the record that talked about this defendant being a security risk or anything like that.
Well,
Was there?
I mean, He was indicted for capital murder.
But
Yeah.
as opposed to other, in other case law where it talks about.
No, I mean, nothing,
in
nothing compared to other inmates in different scenarios. No,
Where they-
he was not shown to be disruptive or anything along.
Because in other cases, there had been individuals who had attempted escape, who had been disciplinary
Right.
problems, and so they found it
Right.
appropriate to hold them as security risk, but we didn't have that in this
No.
record.
And in situations like that, trial courts will often say, all right, we're going to put a shock belt on you. If you misbehave, Mr. Defendant, we're going to let the bailiffs shock you, or we're going to put a leg brace on you. No, that did not happen in this case. No one ever requested that. The issues never came up.
I'd like to ask you a couple of questions about government code provision that's raised on for our consideration, section 24.012E, which specifically provides only that a non-jury matter relating to a civil or criminal case may be held at a correctional facility. The first question I have is the state concedes that this Medina County jail falls within the definition of a correctional facility, correct? Under the penal code.
I wouldn't concede that it's correctional facility in the technical view of it. A correctional facility is run by the Texas Department of Corrections. The Medina County Jail is not.
Does it confine a person who's been arrested, charged with, or convicted of a criminal offense?
It does.
And it falls within penal code section 107, which defines a correctional facility. So the state doesn't contest that the Medina County Jail is a correctional facility.
Well, either way,
Given
I
that-
believe the statute allows it to be conducted in the fashion it was conducted.
So I'm gonna give you another 1 minute, if I may, just so that you could try to answer this question. If the government code provides that only non-jury matters are to be held at a correctional facility, how does the state respond in this case?
Well, if that's the spin that the court finds applies herein, I suppose that it should never have been tried there, but that still brings us back to, all right, how is he harmed? Because it's non-constitutional error, because it would merely be a violation of a statute, and he'd have to show harm, and he hasn't even attempted to do that.
So short of attempting to ask the court to put a spin on a statute, I think the statute is quite
Well,
clear.
interpretation.
If I may not be interrupted. Thank you, counsel. Again, your response to that point of error.
Well, if.
Does the state concede that it was in violation of government code
No,
section 20?
I don't concede it was in violation of the government code, no. We've
So
laid
a
out
district-
what we believe the appropriate statute that governs the situation. It's in the state's brief.
Very good. Thank you, counsel.
Sure. We'd urge the court affirm the conviction. Thank you.
Couple of thoughts, Justice Martinez, to pick up where you left off. If we look at 24.1012E Echo, there's no spin whatsoever, Judge, on showing that a non-jury matter cannot be heard in a jail where the correctional facility, it falls under that definition of 1.07A14, because the Medina County Jail was a place designated for people arrested for, charged with, or convicted of a criminal offense. In fact, Chief Rodriguez admitted that in his testimony, and he confirmed that. So when you look at Chief Rodriguez's testimony at the hearing, he says, yes, I agree. It's a correctional facility under that definition. Now, the government cites the local government code to try to say it's more specific. We don't think there's a conflict between the two whatsoever. The local government code cited by the government says that the county and the county commissioners can select any building they want to try a case. However, they still have to comply with 24.012E, where it can't be tried in a jail. A trial case cannot be tried in a jail if it's a correctional facility, and that's what we have in this case. It's also our position that security, the mere fact that it's possible that jurors serving on a case could see a citizen accused in cuffs or shackles is not a security concern. It does not justify having the case in the county jail, because Justice Rios, as you pointed out under the Estelle case in that language, that it may be more convenient for jail administrators, provides no justification for the practice. And that's exactly what the state is relying upon in this case, is that it be more convenient for jail administrators. They could have easily done like they do here. They could have brought him over early in the morning, well before the courthouse is open, well before jurors even arrive, and they stick the individual in a holding cell. And then the jurors get here and they have no idea about any kind of shackling or cuffing. And it certainly does not serve any state interest or policy to try to keep him from being seen by the jury. That's not what the state interest, state policy is, like it would be with shackling or gagging. With respect to the jurors' state of minds, I know that I think Justice Rodriguez, you asked if there was any, and Justice Rios, if there was any evidence, you asked the government, any evidence about what the jurors thought, or the jury instructions, what was the effect of the jury instructions at the end of the case. And we would just like to point out one more time the Holbrook language. Assessment of jurors' states of mind cannot be dispositive here. If a procedure employed by the state involves such a probability that prejudice will result that is deemed inherently lacking in due process, little stock need be placed in jurors' claims to the contrary. Even though a practice may be inherently prejudicial, jurors will not necessarily be fully conscious of the effect it will have on their attitude toward the accused, especially true when jurors are questioned at the very beginning of proceedings. At that point, they can only speculate on how they'll feel after being exposed to a practice daily over the course of a long trial. Whenever a courtroom arrangement is challenged as inherently prejudicial, the question must be not whether jurors actually articulated a consciousness of some prejudicial effect, but whether rather an unacceptable risk is presented of impermissible factors coming into play. The Holbrook language that I just cited is exactly what the court has in this case, we respectfully suggest. It's not the case where we have to show harm. We can't show harm for the exact reason employed by Holbrook in the language from Holbrook.
Counsel, I believe the court fully grasps the notion of what appellant wants to convince the court of, that this is an inherently prejudicial setting, and thus any finding of actual harm or actual prejudice is inapposite. I think the reason why the state counsel for the state wants to just hang their hat on actual prejudice, because it disagrees with the appellant's position about inherently prejudicial, and wants to focus on the required analysis of actual harm should the court not find that it was inherently prejudicial. So let's just skip to that point. If the court does not determine that this was an inherently prejudicial environment, and thus the appellant would have to show actual harm, that it was less than inherent, how would you respond to that? What's the evidence of actual harm to the defendant?
I think that under the Estelle case, Your Honor, where the Supreme Court dealt with the whether or not harm resulted from forcing a citizen accused to wear jail clothes during trial, the Estelle court said you can't show that. It's just not possible. You cannot get back into a juror's minds and mindsets on seeing that citizen accused in jail clothes the whole time. And so that's why we believe, Your Honor, under Estelle, that that's why this court should find inherent prejudice, because both in Estelle and Holbrook, the U.S. Supreme Court said there's just some things you cannot do. And you cannot expect the appellant or the defense to do. I mean, on a motion for new trial, I could have called all 12 jurors and asked them how it affected them. But the case law says it doesn't matter. And since it doesn't matter, then we shouldn't have to show actual harm. Now, if this court decides we have to show actual harm, frankly, I believe that's a legal impossibility. I don't know how you can go back, just like under Estelle, for instance, when the jury was watching a citizen accused forced to wear jail clothes during trial, that it's not something they're able to articulate. And so that's why the U.S. Supreme Court says that's something the appellant should not have to do, especially in light of the Oregon versus Cavan case that we cited in our brief, where it said holding trial in a jail infers that a defendant was so dangerous that he could not stand trial in the public courthouse, which created a trial environment that was incompatible with sustaining impartiality. And, you know, in the Cavan case, I don't see how a jury could have articulated that. If each one of them were called one at a time on a motion for new trial. So what did you think when you walked in the Medina County Jail? What did you think when you had to, you know, you saw all these heavy metal brown doors that said security, do not enter? You hear these things banging shut. I don't know if you all have been in jail before, but when you're there at the Medina County Jail, those heavy brown doors are clanging shut with a loud bang. And then you have these people staring at you from behind these bulletproof glasses. It is not the kind of environment that you would see down at the courthouse. And like these cases that we cited, like the Jaime case, for instance, a normal juror never goes to the jail.
Mr. Gross.
They have no idea. Yes, you're.
Just assume with me that the court does not find that holding trial at the jailhouse courtroom is inherently prejudicial. The case law says that then if there is no inherent prejudice, then we need to look at actual prejudice. There's also a case, I think it's the Simpson case, that says, and I know you're saying it's very difficult to show actual prejudice, but just bear with me for a moment. The Simpson case says that the test to determine actual prejudice, the result of external juror influence, would be whether jurors actually articulated a consciousness of some prejudicial effect. And do we have anything in this case that would show that the jurors ever articulated any prejudicial effect?
We know they saw prejudicial effect. We know they saw every day in a capital murder case him being tried in the jail. And we know they saw these heavy brown doors with attorneys waiting to see clients behind those heavy brown doors. This isn't an empty space that we're talking about during the trial. There are attorneys waiting to see clients behind these security doors all the time. So it's our position. You have those photographs show more than enough actual prejudice. I mean, to walk into an austere building like that you see from the front and to go through the immediate security with all the warnings, and then to see all those heavy security doors back behind there, that's actual prejudice, Your Honor. And that's something we know that the jury saw every day when they went in there for trial. And so unless there are any other questions, I see my time is up, but I want to thank you for the opportunity to come here today. Thanks.
Thank you, counsel. Your case has been submitted and an opinion is forthcoming. The court is adjourned.
All rise.
Carry on. Good save.